Good afternoon.
Good afternoon.
Wake up. Keep awake. This is the reality show, What is the State Planet? And I always think that's a misnomer. I call this What is Life Planning, because it really isn't what's going to happen after you die, even though it involves it. It's what you can do while you're alive to help you, your beneficiaries, your heirs, your family, your friends, to make sure everything goes smoothly. Because all those TV shows which they show the families fighting over each other over the littlest little tea set, they're true. We've seen them. And you would be surprised what people will fight over and the lack of monetary value. Or you see the problems, and you see it all the time, is a husband and a family goes into a car, they have a car accident. Mom and dad pass away. What happens to the kids? What happens to the assets? What happens if there's a fight between mom's side of the family or dad's side of the family? What happens if there's one divorce or two divorces? It can happen. The cases are out there. So what we're trying to do is make everything planned out to avoid problems so you have some peace of mind. No, we can't plan on everything, but we can at least give you the options so you make the decisions. You plan. You decide to take any possible risk or not take any possible risk. Everybody thinks they're going to live forever. Everybody doesn't want to sign their name to a will because it means, uh-oh, something's going to happen to me. I don't want to think about it. I'll put it off. I'll call the attorney later. I'll do something later. You can't do that. You got to plan now. But it should be at your timetable and not under the force of an emergency. So, I'd like to introduce myself. I'm Ron Hack. I'm an equity member, partner of Evans & Dixon, based in St. Louis. Speaking with me today is Dan Simon, another equity member, my partner from the Columbia, Missouri office. We'll try to help you and answer questions. We are leaving time for questions, but if you do have a question that you think everybody, quote, in the class might enjoy, raise your hands and we'll try to answer it. This is the primer class. So if you're expecting the high school course, as they had in that one Mexican chalupa course, advanced chalupas, sorry, that's going to be down the hall next year, whatever. So we're going to give you time to answer questions. We're going to ask you a couple questions too. We're going to try to make this fun, interactive, and at least keep you awake. So we'll go from there. So, to probate or not to probate? That is the question. And I do a rotten William Shakespeare. What is probate? You've all heard the term, the official proving of a will. Well, who you got to prove it to? It's a piece of paper. You got to prove it to the court. You got to prove it to all the official entities as to how you want your assets to go. Well, there's three things you need to know. If you don't have a will already, congratulations, you do have a will. Because the state of Missouri has already written one for you, and it's by law as to where your assets go. Congratulations, you have entailed, because of you don't have a will, lots of expense and attorney time and problems because you got to go into the court at every second to get approvals to sell property, buy things, find out what's going on, what your wishes were, etc. You don't want that, but the state of Missouri has already provided it for you. What's the other purpose? To establish the validity of a will. Several times you hear of wills, 2 or 3 wills being submitted. especially by these old people like Howard Hughes that couldn't make up their mind and kept writing things out. You're going to see more of that in the future because everybody thinks, oh, all I have to do is go online and I'll just grab a will and fill it out and sign it and that's it. First rule, didn't I tell you about? That isn't a will. It hasn't been properly witnessed. Second, you could draw the form that is great for California, for New York, for Florida, that doesn't comply with Missouri law. You're back to intestate without a will. More cost, more money. Yes, you can do it yourself, but it may not be what you want. And that's what we're here today, and we'll help you with what you want. Not probate. Simple, not. What's the other option if you don't probate? To establish a trust. That's a written document that establishes where you want your monies to go after you're dead. But it's got another additional benefit. If you become disabled, it provides who will look after you, a trustee, someone you name that you trust to look after you if there's no one around, especially to ask for you. Sure, everybody says, well, my spouse will take care of you, and that's great. But what if you go back to the car accident and both you and your spouse are in that car accident? What happens if you survive disabled and your spouse dies? Who's going to look after you? Not your 10-year-old child, not your 10-year-old grandchild, not the ex-wife or ex-husband you wanted to get rid of 20 years ago. You want to have somebody who's going to look after your best interests. Probate, as I said, the official proving of the will was in probate. Dan will talk to you about how long probate lasts. I'm not going to get into it. However, to give you one story, and this is true, it took me, because there was no will, over 3 years to finally finalize a probate estate. All that was in the probate estate, one house that went down from $25,000 to $20,000 in value, and a couple $1,000. But we still had to go through probate to take care of the title to the house. You don't want to do that. You want to make sure everything is taken care of ahead of time. I'm going to let Dan now take over, and he gets to ask the first interactive question.
Thank you, Ron. The first question, you must have a will to avoid probate. Is that fact or fiction? Does anyone know?
Fiction.
It's fiction, because probate is the act of proving a will. It's run by a will. It's the will directs probate. So the answer is a will simply directs probate. Ron was a little negative about probate, and I'm not necessarily the defender of probate. I don't necessarily recommend probate to anyone. But probate isn't the worst thing in the world, and it doesn't have to be that contentious or take that much time. Probate is used for both decedent's estates, whether testate with a will or intestate. It's also used for incapacitated or disabled persons. Incapacitated typically, of course, means someone who doesn't have the mental ability to meet the criteria necessary to transfer property or enter into contracts. There's actually a different level of capacity you need to enter into a contract than you do for a will. You need less ability to give away your stuff than you do to contract to buy, sell, or enter into an agreement with somebody. Incapacitated and disabled people need either or both guardianships or conservatorships, and guardianships can be either partial or they can be full guardianships. So a guardian, somebody that guards the body of the person who is incapacitated, a conservatorship, the person who looks after the money of an incapacitated person. Incapacitated also refers to children, people under the age of 18. So you don't have to be physically incapacitated, mentally incapacitated. You could be not old enough to own property. And so the car accident Ron was talking about, where the parents die, if the children are young, the property, when it does get to the children, will have to go to somebody to watch over it. And that's typically done in a guardianship, in a conservatorship. The decedent's estates, talking about testate and intestate wills, Ron mentioned that a will, can take a long time to get through probate. In Missouri, if you die and you owe people money, if you have any claims against you, those claims have to be made within a certain period of time. You have to present a will within a certain period of time. There's time limits that try to make ending the person's affairs as efficient as possible or not drag on forever. So after a year, if you have not submitted a claim against the decedent, if you have not probated a will for a decedent, those opportunities are gone. If property is discovered after a year is gone, there are processes to handle that, and it would typically be intestate, unless, of course, you've admitted a will. The purpose of probate is to ensure for the most organized method of ensuring that someone's affairs are taken care of. It's done in a public forum. You can go look in the public records and see what somebody's will was. If they have assets that were probated, that means that they had assets that had to be directed through that will or without a will, and the whole world can know what that is. And with court records becoming more and more available online, using the probate process also means making your own affairs public to everybody to see, so they know what your kids got, who got left out, who got the china, who got the money, who got the love, who got your assets. I always kid my brother that I've taken care of our parents' estate. He doesn't have to worry, and that when mom and dad are gone, he gets all of their love and I get all of their stuff.
Fair.
Right. The question, I would probably have answered this, but if you don't have a will, is it fact or fiction? If you don't have a will, the state will get your property. Does anybody have any ideas? What's that?
Fiction.
Fiction. Again, the reason that the bacon is on there is because in Missouri we go through 9 degrees of separation, 6 degrees of separation from Kevin Bacon. Just looking for something that. So right, you go through a long list of your nephews, cousins, sisters, children before you get to, well, there's nobody to give this estate to, so it goes to the state of Missouri. It could get there. I was representing beneficiaries who were getting 1/274th of their great aunt's estate because she died, had no children, but had 9 siblings, and of the 9 siblings, 2 of them were living and 7 of them were dead. And of the 7 that were dead, some of them had 2 children, some of them had 4 children, some of them had 1 child. My client had 3 siblings, I think, and if I remember right, it was 1/274th of her deceased aunt's $5 million estate. So it was worthwhile to the attorneys and people that were manipulating that estate to distribute it. And 1/274th worked out to be, I want to say she got $20,000 or $30,000. So it wasn't like she got nothing. But had this person had a will, had this person had a trust, first of all, the expenses would have been a lot less. They would have been able to avoid, I'm sure, you can sort of figure that an estate that does not have, an estate that goes through probate is typically going to pay approximately 5% of its assets to the personal representative and the attorney that represents the personal representative. So if you have a $5 million estate, about $250,000 of that goes to, I'm sorry, is that right? Yes. $250,000 of that will go to the attorneys and to the personal representative, half to each. Had that person set up a trust, it probably would have been, you know, $2,500, $5,000 to the attorneys to prepare the documents, and it probably would have been, you know, there may have been thousands of dollars in the dividing of it, but this lady, in the example I'm using, had all securities. So it was a stock account or two. It would have been very easy to distribute it. But finding the 274 descendants and heirs, I guess is the right way to say that, finding the 274 heirs is where the all the time, effort, money goes into place. Had she given it to charity, had she given it to you know, just her siblings, whatever she wanted to do, it would have just been a lot easier. Plus getting 274 people or whatever to approve settlements and read, you know, you have to give notice to everybody, you have to always send out, not only does the public get to know about it, but the people who are interested have to get written notices in the mail telling them what the transactions are, what's going on. And you typically don't close an estate for a year after the person dies. So if you immediately went to handle their affairs, you'd wait a year before you even started complete distributions and things like that. With the trust, it's almost instantaneous. The death of a person doesn't change the trust other than to be a triggering event for the purposes of distributing the assets or taking care of somebody or doing whatever the trust document says it should do. I skipped ahead too quick.
Can we ask questions?
If you have a question, sure.
Okay. Regarding a living will, or I'm sorry, this living trust. If you have a living trust set up, then do you need a power of attorney, a living will, and a will in here in Missouri to be on the living trust?
Okay, so that's something that Ron was going to get into, but if you don't do those things, then you could have, during your lifetime, guardianships, conservatorships, and at your death, a decedent's estate that is probated through the local court. All of those would be through the court. All of those are managed by the court. You report regularly to the court. You have annual reports as to what's going on with the ward if it's a guardianship. You have annual reports as to the use of the assets. You have to get permission every time you want to spend a nickel out of the estate for a person who's incapacitated. You can typically get a budget that could be used, but at the end of the day, it's a tedious process. If you want to avoid guardianships, you use living wills. You want to use, and healthcare powers of attorney. If you want to get rid of the conservatorship, you use a power of attorney for general purposes, for financial reasons. So somebody, while you're incapacitated, can make decisions for you. And if you want to avoid using a will so that you don't need a court to describe where your assets go when you die, you can use a trust, you can use you can use property ownership, you can own something joint tenants with right of survivorship, you can own it with your spouse, which is tenants by the entirety of Missouri. Everything we're talking about is typically Missouri. These things can be modified a little bit for other states, but typically the rules are the same. And then you can just do beneficiary designations on things. Your bank accounts can have TODs, PODs. You can have your vehicles in Missouri can have a TOD on it. Your house can have a beneficiary deed so that you can avoid using a trust or a will. But we break that trust or a will, we break that up into either probate, where you're using a will, or anything else other than using a will. We call that non-probate. And with that, unless there's any other questions about the probate process, let me also say, I said it's not the worst thing. Probate is not the worst thing. There are circumstances where people's kids and everybody close to them are so already against one another that you don't trust any one person. You don't want to hire the local bank to take care of your affairs, or they won't do it to be a trust company because your affairs aren't significant enough. You might have $100,000 worth of assets. There might not be a lot of trust companies that want to take over managing $100,000 assets to divide up among 3 or 4 ungrateful children who can't get along and who don't, or who have such special needs that money isn't going to mean anything it's going to be more of a hassle or a burden than a benefit. So the probate process isn't wrong. It's not, you haven't made a mistake if you get into the probate process, but there are typically better ways, and most of my clients, after having discussions and considering how to plan their estates, we find ways to overcome an estate that might not be large enough to need a commercial trust company, but definitely needs something so that you don't have the kids fighting over who gets the farm, or whether you sell the farm or you keep the farm, or whatever that may be. So with that, I'll let Ron take over non-probate.
And this is where we go very quickly, but answer some of your questions. And let me get to the first question that was right there. And the answer, do I need all these documents? And every client says, I don't need all that. If I got a trust, why do I need a will? Why do I need a power of attorney? Why do I need it? The trust only administers what is in the name of the trust. As an attorney, I can't title your bank accounts and put it into the name of the trust. Only you can. Therefore, a will is necessary, what's known as a pour-over will, so that anything that isn't in the name of the trust gets administered as if it were in the trust. So, what is a trust document? It's a document. It is private. It is not filed with the court. So nobody needs to know after you're dead or while you're alive what's contained therein. It's instructions. It's instructions after you die. Who to make the request to, $200 here, $100 here, $300 to this charity. But it also provides for your care while you're alive. It provides for the care of someone else, such as your children under the age of 18, or if you want to provide monies so they can go to college, receive technical benefits, or, and this is what you see nowadays because Missouri's approved them now and the government has, special needs trusts. Many families now have people who are receiving government benefits because of educational disabilities or other disabilities. You want the money to go for the benefit of the person, and the government doesn't take the money, because if you put it in the name of the child once they reach 21, the government's going to take it for Medicaid, Medicare, etc. You have to establish a trust to provide for them. That includes old people, young people, any age people. You want them to still be able to get their government benefits, and the government doesn't take it. But there's a trust there to provide something extra. It provides for how eventually you want your property to be divided. It provides that you don't go into court to sell your main residence if you still have one. You don't have to get court approval with an order and everything public. You do it privately. It provides a way to make it seamless, quickly, as Dan was saying, in most cases. Now, who do you name as a trustee? That's really someone you trust. Yes, you can have a bank, a fiduciary company if you can't find someone. Usually, however, it's a close family member who you trust. Doesn't need to be. Can be a close friend. Sometimes there's nobody. Can an attorney be a trustee? Only if you put his arm around his back and do it, but yes, I've done it, because literally there is one person left, and there's nobody left, and you need somebody to help them. And so now the family members have been estranged for 30, 40 years. Happens many times. And then you've got to find someone. I don't like to do it. I won't do it unless there's literally nobody else. But usually you can find someone. So, the trust owns the property. What does that mean? It means, as I like to say, there's a shadow. While you're alive, this trust is the entity that owns the property. But you are your initial trustee. Now you can have a joint revocable trust if you're married, or a single person revocable trust. For tax reasons, and I don't want to get into all that, sometimes you divide up your assets for taxes. Right now, taxes come in, it's a little more than this, but $5 million. If you have $5 million in assets, including, or more than $5 million, including all insurance policies, etc., then you've got to take care of tax considerations and tax entitlements. If you have under $5 million, then you don't have to be as complicated. We're not going to get into that today. That is very, very individual. But the trust owns your property. That means we have a document that says it owns all your furniture. It owns your car collection, if you want it. Sometimes you don't want to put the car in a trust and you make it a transfer on death, a TOD, or a beneficiary deed on death. Reason why you don't usually put the cars in the trust is you have very little lines on the documents you've got to sign. You trade in and out of your cars all the time. It's easier to do a TOD and then just create, when you sell your current car, unless it's a collector, you have a new TOD later. It's a lot easier. Ownership of property. People say, well, I don't want to do a trust, I'll just put it in joint tenancy. That's great when you're husband and wife, then whoever survives gets it. But then what happens then if both of you died? Then you got to go through intestate probate. You can add, okay, and several times people have done this, is mom has decided, I'm going to add daughter to it as a joint tenant. Well, that means daughter has a right. It may have tax consequences, but has a legal right to that property. If somebody gets a lawsuit against daughter, or a creditor comes, then they can try to force the sale of that property to get the daughter's debts. What you see a lot of times, however, is mom and daughter have a falling out because daughter marries somebody that mom doesn't like. But daughter then doesn't want to get off the deed. And so you've got the daughter and the husband that you don't, or spouse you don't like on there, and spouse could inherit daughter's interest, which is not what mom wanted at all. You can have tenancy in common, etc. You can have a beneficiary designation for real property as well as personal property, transfer on death, beneficiary deeds upon my death, it's transferred to daughter. Same problems though. What happens if mom and daughter have a falling out? What happens if daughter's been through lots of divorces or son's been through lots of divorces and they're afraid that the ex-spouse is going to get the property? You don't want that either. The trust can make sure that the grandkids, for example, get the benefit and the money, and it doesn't go to someone else. That's why you got to plan. We can't give you all the answers in a meeting like this. We can raise the questions, but you've got to plan how you want it. We've gone through the different ways of ownership. You've got life insurance, retirement plans, and annuity contracts. The laws on that depend upon whether it's a 401k or all the other things, whether it can be held in a trust, not held in a trust, whether you can have a POD or TOD. Again, that's something we can explain it to you and go through with you. And once we know the particulars, we can say, transfer this one to the trust, don't transfer this one to the trust. And we'll make sure how you get it transferred so it's set up the way you want it. And it's not immediately that a 23-year-old gets $250,000 from a life insurance policy. Some people want that, a lot of people don't. A lot of people, for example, you can apply in a trust You give part of the money at age 25, another part at age 30, another part at age 35, thinking that by the age of 35, they're going to know what they're going to do. Some people, and again, I always like the old movies where you hear about that it's called a spendthrift trust, and the person never gets a dime, and it goes to their children because you know this person just can't keep monies or is just liable to be taken in by everybody, and so you want to protect them. Again, it's very particular. Incapacitated, disabled people. As I said, the trust can establish a special needs trust for someone elderly, someone young, someone in between. It takes care of yourself if you become incapacitated or disabled. Addition to the trust document itself are the powers of attorney. We've all heard them. The healthcare power of attorney. Everybody goes into the hospital now, they say, do you have a healthcare power of attorney? It's a usual small document that says, this is the person you can discuss my healthcare with and help make healthcare decisions. You can have a separate document called your living will or your healthcare directive, which decides, I want these extraordinary measures taken, or I don't want these extraordinary measures taken. You decide. You decide ahead of time who's going to make the decisions, who's going to get the information, what you want done, what you don't want done. Just so you know, I also practice in Illinois. Illinois has statutory powers of attorney. That means that the legislature has written these up. They're not mandatory, they're just suggested. Missouri doesn't. So you have a little more leeway in Missouri. In Illinois, I always say, go with what the Illinois legislature has said until they change their minds and change it again. So, financial powers of attorney. You need that, especially if you're incapacitated for a short period of time and you need someone just to sign the checks. You direct them what to do, but you've got someone ready to step into your place and take care of you, or to make long-term decisions for you. There's two types on the financial powers of attorney, especially you need to know. And I run into this all the time. It's called your springing and non-springing. What's the difference? A springing power of attorney comes only into an effect when a certain event has happened. Usually, when you get one or two physicians that can certify that you're disabled and you're no longer competent to make these type of decisions. Some people, however, especially for the elderly, want their son, grandson, whoever, to immediately step in and be able to write the checks and to do everything. It's called a non-springing. It takes effect immediately. You've got to be sure what you want before you sign that powers of attorney. That's why I'm saying don't get the form off the line without knowing what you want, because you could be grabbing the wrong form and not realizing what you're doing. On the springing power of attorney, I've run into problems where the parent wants to retain control of their bank account. The child, for whatever reasons, wants to immediately have control over mom's money or dad's money, and you get into a family fight. Mom really doesn't want to give it to son or daughter, and she wants to retain control, but she doesn't want to fight either. Sometimes you do, but you don't sometimes. You always follow what your client's decision is. The other person is not your client. You follow your client's directives, whether you want springing or not springing. Again, you've got to be very careful on that. It's very fact-specific, family-specific. One other types of power of attorney that's not mentioned in here, and I started doing it about 5-6 years ago, and then I read more and more about it. It's called the power of attorney for right of sepulcher. What's that? It means what happens to your body after you die. It takes care of organ donations, or more likely, if you want to be buried in a certain plot, you can designate that. Or if you want your ashes, you want to be cremated and your ashes spread over, the Pacific Ocean, it takes care of that. You again make the decision, not the family members. Because sometimes the family members, oh, I don't want mom cremated, but mom wanted to be cremated. Again, that's your decision.
What's that called again?
It's called a power of attorney for right of sepulcher. It's in the documents, and if you ask me to spell it, I'm in trouble.
Thank you.
I got spell check.
There you go. Who carries that out?
You designate who's going to have the power of attorney. Who's going to be your trustee? It's usually a trusted friend or family member that's in charge. And what you do, especially on that, you give a copy of that one to whoever you designate, so they know ahead of time, here's my prepaid funeral plan, or here's my prepaid, cremation plan, or here's my organ donor card. You have it ready to go, because in a death situation, people are emotional. They don't have time to look for things. So your purpose is you give it to the people you trust ahead of time. You make sure that I have a copy so the family members know, Mom just died, what am I going to do? Do you have copies of everything? And so I'll retain, or the law firm retains the copies, because that's usually the biggest problem, is finding the right document at the right time with the right copy when you're trying to do everything else. And sometimes the person has answered exactly what they want, and so the family members don't have to make those rough decisions. Or if there's a family fight, you've got one person that makes the ultimate decision, and that's it. There's no family fight. You don't have to fight. And again, divorced families is where you really see that sort of thing. When you got one man who's, for example, had 3 wives, and they each had kids, and the kids all want dad next to mom, it could be divided, but he may not want to be next to any 3 of them. So, we're not going to get into that. You decide. Living will, as I said, decides what you want to be done, what extraordinary measures you want. People are very strident in their views on this. And as time goes on, it's very much an individual choice, especially if they see a family member go through the stuff and they say, I don't want that. Well, unless you have a document that says it, you're going to get it. Again, it's with the consultation of your family members, the consultation with the doctors, the consultation with your specific fact situation at the time, but at least you let them know what your preferences are. Remember, your preferences can change, so you go with the last one.
So if you already got a living revocable trust, and it was done 25 years ago, you could go and you can have another one done.
You amend it.
I see.
And it's easy to amend. In fact, if you haven't looked at that in 20 years, you're creating a problem for you, because things change. People change. People die. Who nominated insurance trustee may have been your best friend 20 years ago, has moved away, and you have no idea where he is. You've got the relative that you trusted then, and you had a big fight because of a Cardinal versus Cubs baseball game, and you're not going to talk to that Cubs fan ever again. You don't want them anywhere near your Cardinal hat collection, which they burn, but you want it preserved. You make the decision. That's why I call this life plan, not estate plan. And that's what we here in our department do. We meet with you, we work with you as to what you want. We give you options. We don't make the decisions. Yes, go ahead.
Just a quick question. Like when you do a power of attorney, like you said, for financials, that's only good while we're alive, right? It's revoked,
Correct.
Okay.
The minute you die,
It's no
and the
longer
provision
on.
is in all of them, it ceases.
Okay.
That's
Bank
for any power of
institutions-
attorney, correct?
Correct.
Yeah, okay.
Except with their right of sepulcher and except,
Okay.
there's some other minor exceptions, but generally, for the banks.
Yeah, like for
The
the bank
banks,
accounts and things.
all
yeah.
of them say the minute they are informed of your death, frozen. You can't do anything, which means you better have that trust document right there, ready to go, saying, oh, that's true, but I've got the title of this in the trust, so yes, the trustee can immediately assume power to pay for my last expenses of my funeral, my last hospital bill, and everything else. And that's why everything is coordinated and we explain things to you. One other document that I usually do, and because I ran into one hospital in St. Louis, usually the HIPAA requirements are always in your combined healthcare power of attorney and your healthcare living will. One hospital locally said, no, we want a separate one-page HIPAA document. And so I always have a one page that says, go back to the healthcare power of attorney. Here's your one page, but you know, this is valid too. So you learn over the years what the banks want. Another thing, especially on the springing versus non-springing financial powers of attorney, sometimes the family all agrees, it's the banks that are saying, well, where's the 2 letters from physicians that says she's incompetent? I won't accept son being power of attorney. Well, she's in a nursing home and she can sign, but she'd rather not. No, I want to see 2 letters from a doctor under this format before son can pay the power of attorney bills, even though mom and son are both agreed, everybody's agreed. So again, you've got to be very careful on all of these things. It's just not as simple as pull a document off. One final question, fact or fiction? And we've got freebies up here. And I'm going to let Dan give them out because I'm going to let him watch to see who puts their hands up 1, 2, and 3. So everybody gets something. Well, first 3 gets something. Fact or fiction? I can only give away $10,000, $14,000 a year without paying tax. This is the Dan question. Dan said also does all the corporate and financial things. So I'm going to let him answer. I'm just asking the question. So put up your hands if you think you know the answer.
Fact.
Okay, we got 3. And Dan, the answer is.
You can give away $10,000, $14,000 actually now indexed for the current schedule, but without reporting it or paying tax. You can get $5.5 million per person. I can give away $5,500,000. My wife can give $5,500,000 and still not pay any tax because you get a credit that is a lifetime credit of a number that would be the amount of tax that would be payable on $5.5 million of assets. So the idea that you can't give away more than that is only the idea that you don't have to report giving away more than that. All right, up to $14,000.
Dan, is it per person? I mean, can you give $2,000 to cousin A and cousin B and cousin C?
Right, I can give $100 million away at $14,000 per individual that receives it. But during my lifetime, I can only give more than that, $5.5 million, or up to $5.5 million. So if I gave away $14,000 to the city of St. Louis, every person that lived here, I wouldn't pay any tax, they wouldn't pay any tax. If I gave away $5.5 million to one person, I'd pay tax on all but I would be subject to tax on all but $14,000, but the credit would make it so you don't pay any.
Go ahead, please.
But if you do give more than $14,000 a year to one person, you have to have a gift tax return filed.
You would file a gift tax return saying I gave away this much money or property.
Any other questions? Yes.
This is going to be a hard one to answer, I think, but do you have an estimate of what it costs when, say your average paperwork that you would do for estate planning, well, how much does it cost?
Everybody wants to know that.
Well, yeah, because that's why we don't do it, right?
How much does it all cost?
How much are like
Our
our
estate
fees?
plans, yeah. Now, we have some standard rate things, plans, standard rate for services, but it can't be individualized. I always say, until I talk with you and know the details, I'm not going to give you a range because
No range?
yes. Yeah,
I'm more aggressive than that.
He's more aggressive.
I would say a young couple that comes to me with they just had their first child or about to have their first child and they think they need something like this to name the person they want to take care of their new baby if they can't handle it. That is something that I'll usually do on a somewhat low fee, somewhere under $1,000.
And I agree with him on that. I agree with him on that.
I threw out a number earlier that the lady who gave away $5 million because she didn't have a will or a trust through intestate succession would have spent over $250,000 in legal fees and personal representative fees alone. And I said, or she could have paid $2,500 to $5,000 and set up an estate plan that would have avoided that. And that's not unreasonable for somebody who has one asset. It's a trust. I mean, it's a security account.
It really depends also on how many pieces of property you have to prepare warranty deeds for, to transfer things into the trust.
Many of my clients have limited liability companies that will own some real estate, maybe a rental or something, transferring the L.L.C interest out of their name and into the name of the trust. If it's a single member LLC, isn't a ton of work. But if it's got multiple members and I got to get permission from all those members, that's where the hours rack up. So the first $2,500 to $5,000 of a sophisticated estate plan for an individual or a married person, that's kind of your base number with one or two transfers. When you have a bunch of transfers or business work, succession planning, then we start billing hourly after that. So that's
and what I usually do is after the first meeting, I will give you an estimate and it'll be agreed upon before I start any work at all.
Okay.
So you know up front how much it's going to cost you.
Right, you don't pay to come sit with us for the first time and have us tell you what we just told you in this seminar.
What you think we need.
And find out about it. Right. We'll send you a form, you fill it out saying here's kind of what I have.
Okay.
What
Well-
about amending a trust? The same thing, it depends on how detailed it is to amend a
It
trust.
depends who drafted it. If I drafted it, it's very easy to amend it because I know the form and it doesn't take me very long and I can print out a new one with the changes. If I didn't do the document and you're asking me for legal advice, I want to look at that document, make sure that whoever did it knew enough about what they were doing. So it's going to take me a little bit more time, so it might be a little more money.
And especially if it was prepared under a different state's laws.
This is Missouri, but it's in a different, town, so.
Yeah, and then you remember, if it was
You have to
20
review
years
that.
ago,
Right.
the laws have changed, or your specific interests have changed. Again, it's very.
And I ran it with my parents. They had one that things had changed, and they did it one time, and then I got to pick up the pieces and probate.
And that's what you don't want to do, is pick up the pieces.
You really need to review every 5 years.
Yeah, every 5 years, that's a minimum.
Yeah.
Anytime there's a birth or a death, you should also look it over too.
It's cumbersome, but it's worth it.
Yeah. If you have any more questions, please call Dan in Columbia.